Everybody ready? Start. We may note that Mr. A.S. Chandyok learned ASG appointed as amicus curiae in this matter emphasized this distinction between the letter patent issued qua the chartered high courts and the non-chartered high courts. Stop. This distinction is premised on the existence of the ordinary civil jurisdiction being always possessed by the Supreme Court and thereafter by the chartered high courts from the very inception. Stop. Thus, the high courts established outside the presidency towns inherited only the appellate jurisdiction of the southern courts, while the principal courts of original jurisdiction continued to be the district courts. Stop. This is the reason why the letters patent of the chartered high courts containing clauses 11 and 12 prescribed the local limits of ordinary original civil jurisdiction and conferring the said ordinary original civil jurisdiction on the chartered courts. Stop. There are no corresponding provision in the letters patent of the other high courts to these clauses. Stop. Clause 13 refers to the extraordinary original civil jurisdiction of the high courts which was exercised when the suits were transferred from district courts to the high courts, while clause 15 refers to powers conferred of appeal on the high courts over the decision of a judge of the high court. Stop. These appeals under clause 15 came from two different jurisdictions. Stop. Ordinary original civil jurisdiction which existed from the inception of the chartered high courts inherited from the then supreme courts, and the extraordinary original civil jurisdiction which is not really an original jurisdiction. Stop. Thus, in the case non-chartered high courts, when a suit was transferred from a subordinate court to a non-chartered high court, such a high court could try the suit in its original civil jurisdiction. Stop. It was the submission of the learned ASG that the letters patent of the other high courts did not give any ordinary original civil jurisdiction to these courts because none was inherited from the southern courts. Stop. The extraordinary civil jurisdiction was possessed by the non-chartered high courts because every high court had the power to transfer to itself a suit from a subordinate court within its territorial jurisdiction. Stop. It was thus the submission of the learned ASG that clause 10 of the letters patent as applicable to Delhi can be invoked before the division bench only from such of the decisions of the learned single judge which were given in the suits transferred from the subordinate courts in case of non-chartered high courts, as the question of any appeal under the said provisions from high courts did not possess ordinary original civil jurisdiction. Stop. This is stated to be so despite the fact that clause 10 of the letters patent of the known chartered high courts, including the High Courts of Lahore, was phrased in the same language as Clause 15 of the letters patent of the chartered high courts. Stop.